Okay, so hi to folks at home. We are doing the week 2 Zoom tutorial for contract A. And this week we are looking at a little bit of skills stuff. And we are also looking at intention to create legal relations, which I lovingly call I2CLR because it's easier to type. So without further ado, why don't I, now, if things start to lag when I share, can someone yell out so that I know and we can just stop sharing again? I will put the collaborative notes that I take in the session up online, so you don't have to worry about that aspect of it. But I like to kind of interact and do things like type things down as we're talking if I can. So I'll start doing it, but will someone like yell out, yeah, AJ, please stop doing this, you're torturing us. And I will stop sharing. Okay, so I had one lovely person today on the forum saying, oh no, were we supposed to do all of the reading for homogenous and the homogenous case note and all of the reading for intention to create legal relations and the IRAC all in 90 minutes? To which the answer is, no, you weren't, so don't worry. Their concern was that they took far too long to do everything, and my answer is, you know what, I expected you guys to probably spend about an hour to maybe an hour and a half doing the homogenous case note, and I expected you guys probably an hour to an hour and a half doing the IRAC. Now, what I will have a look for here, because I will share my homogenous case note. Thank you to the folks that that actually submitted case notes to me for comment. That was useful. I hope that my feedback was of some benefit for you guys. Now here, I'm just trying to find my, here we go, case note homogenous. You know what I will do? I'll just talk a little bit briefly about case notes, and then I'll share mine. Actually, I might as well share mine now. How did you go? Who's actually had a bit of a crack at doing the case note for homogenous? Can I have a little, why don't we do a little poll? Let's have a 1 for yes and 2 for no. Yay, who's done the homogenous case note?
I had to read over one of the case notes and found it very confusing.
Yeah, that's why I wanted to pull it apart for you. A lot of people have not. Of the people that said they haven't done the case note, have you read the homogenous case yet? Is that a 1 for yes, 2 for no?
I had to read over that too, but still confused by it.
Okay, that's perfectly okay. That's what we're here to troubleshoot. Okay, so there seems to be a decent smattering of people that have at least read homogenous. What I would suspect would be a little bit of confusion around the case itself in terms of the way it went down. And I tried to explain this a little bit on my video for you guys. And it's fairly detailed, but we can have a little look at all of that. Valentin, I might just get you to mute your mic if you could. That would be great. So what I will do is I'll start sharing. Now, homogenous case note. Where are we? You know what I'm going to do? I'm just going to share my, now what is this week 2 tutorial? I'll just share my desktop. Here we go. And then we will look at homogeneous. Okay, here is my case note here. Alrighty. Now, when you were confronting, and this is one of the reasons why we started off doing case notes with the Carlisle case, because obviously that was a much simpler and shorter case for you to kind of get your head around. Usefully, the Carlisle case, one of the reasons why I chose that was because it covers off, that particular case covers off a very short discussion on most of the week's worth of work that we'll have for the front end of term. So for Carlisle, they had a little bit of a look at intention to create legal relations. They had a little bit of a look at certainty of terms. They had a little bit of a look at consideration. They did a little bit of distinguishing of a case. And so it was a good entree into the world of writing case notes. Now, the reason why I'm getting you to do case notes this week and last week is because it helps you to get your head around scouring through a case and looking for the bits that interest you and that you can kind of see might form part of the legal issues that were discussed and answered in the case. The reason why is because it's good for you guys to start to get your head around a couple of really uncomfortable facts. And some of the discussion on the Moodle Discussions Forum was headed in this direction, and I was quite glad that it did. It sounds very simple, you know, when you read it in GRAW. Well, a ratio decidendi is the formally accepted reasons for the decision in a case. Yes? Sounds like super simple stuff. But then when you come down to it, you rapidly realise that trying to formulate in your mind what you consider to be the ratio of a case can be quite tricky. Because in our system, it's not like the Americans where, you know, they all join together unless you're in dissent. So it's easy peasy. You've just got the ratio, whatever the main judgment has said, you're away because you know that the main points that come out of that will be your ratio. However, in our rather inconvenient common law system from the UK that we've imported, you have judges very commonly just all writing their own separate judgments. Inconveniently. And so you kind of have to scour through and work out where the points of consensus are. That's your first task. Your second task then is, because all of the judges obviously have used different words to express their opinions, you've got to apply your own personal language filter to try and interpret where the similarities and differences are for each of the judgments and how you can word the ratio so that it will broadly encompass the matters that were actually decided in a particular case. And that's just a really long-winded way of saying, welcome to the world of lots and lots of shades of grey and almost no black and white. And if you're a mathematical person, that will annoy you no end. But it's probably one of the reasons I best love law, is because it all really does come down to language, interpretation, and argument. And this is why I keep saying to you folks, You need to be masters of language, masters of argument. You need to be able to spot fallacies in argument if you haven't touched base with the discussions that happened on the Moodle Week 1 forum. I would recommend that because I posted a little link to a helpful website that shows you how to recognise certain fallacies that might be apparent from an argument. So you guys really need to kind of wrap your minds around, you know, law is not an exercise where you can hunt and peck. That is like a chicken. You can't go scratching around in the barnyard and peck out the answers, because there are no answers, really. There's just responses that are more correct and less correct. And even if they are more correct in 1 year, they may be found to be incorrect the very next year, the very next day. Okay, this is the beauty of working with law. It's shifting sands. Okay, so you need to be prepared for that to some extent. And so writing a case note is a great way of coming to grips with this whole issue. Okay, as you move forward in your law degree, your process of writing case notes, and in fact, as you move on in this unit, and certainly for Contract B, you will truncate this case note writing process right down. And I've already had discussions with the Contract B people about how to write a good micro case note. And I would encourage you to write a micro case note for most of the cases that you come across in your readings each week, okay? Because then by the end of term, you'll have a nice handy little compendium of case law. What I used to do was alphabetize them. And then, you know, if you come into the exam and you think, oh, I need to find out what was that fact in homogeneous that I wanted to look up, you can go back to your little mini case note and it's right there for you. You don't have to go thumbing through the text. Really, in the exam, I would counsel against using the text if at all possible. The other way of organising your notes would be to do it week by week. And then I would just have week 1, you know, week 2, week 3, and then have your cases listed under there. But getting you to do the Carlisle case note and this case note is quite useful because, as I said, Carlisle was a little bit more black and white, and I went through that on my little video that's actually up on the under the skills tab on Moodle. But I'll just open it very briefly because some people have said to me, oh, in the video, you didn't take us down and show us what you considered to be the ratios of that case. And yes, I said ratios. So the plural of ratio decidendi is ratios, like the Ramones, if you liked them in the 80s, ratios. So this was my case note for Carlisle. And just very brief facts, because basically no one's going to be seeing this except for me and, you know, you guys. And I already am aware of the facts, so I just need something very brief to jog my memory, okay? In the exam, all I would be needing you to quote is Carlisle. Easy peasy. I don't expect all of this. However, it can be useful to pop into your case note on the way through in case, you know, something like this crops up for your assignment and you want to, you know, have it all there for yourself rather than going back to the text to find out what the citation is. So then I just went through that old exercise, go through the first judgment, look at what the main issues were that they talked about. Now, I've had a discussion with one of the students this week and she said, you know, how do I even know what to look for? And to some extent that's right. At this very, very early point in term,
you haven't had a whole lot of exposure to the actual legal principle. So you're going to be a little bit patient with yourself, because it will be a little bit of fossicking about and doing a lot more close reading than you ordinarily would, just in this early stage, before you've had a chance to pick up on what the main headlines are, I guess, that we're going to be discussing in Contract A. But as I said on the video, you know, the main things that we talk about are intention to create legal relations, capacity, offer, and okay, I've started you off. What's the holy trilogy? There's offer. What's the next one? What comes after offer? Someone's in the chat box. Chat. Acceptance. Thank you, Jackson. That's it. And then the last one. Beautiful. Thanks, Amy. Consideration. So you've got your prerequisites: offer, acceptance, consideration. You've got certainty of terms. You've got how to find out the terms themselves. And then you've got privity, okay? So they're the main headlines that we're going to be discussing in Contract A. And, you know, you can glean that from just looking at the chapter index on Wilmot. They go through a couple of arguments that weren't really even worth discussing, so they just throw them out the window, basically. So then they go through, was it intended to be a promise? And here they're talking about, was there intention to create legal relations? Or was it mere puff, okay? And Lindley goes through then, was it legally binding? And why was it argued not to be legally binding? Because it wasn't directed at anybody in particular. So they said, can we actually have a legally binding offer if it's addressed to all of the world rather than just one person? Then we had this issue about acceptance. Then we had this issue about certainty of terms. Then we had an issue about consideration. And then we had this nice little distinguishing going on of Gerhard and Bates that I just wanted you to pick up on. So they said, yes, you know, there is this case out there. However, in that particular case, the issue they were looking at was privity. Okay, they weren't looking specifically at the question of consideration, so we don't consider that to be binding on us. What did they mean exactly? Sorry, Lachlan, by mere puff. Was that in relation to the use of the product? That was in relation to the whole advertisement. So basically what the argument was is that, this is just, in technical legal terms, and believe it or not, these are technical legal terms, mere puff just means an empty, embellishment, okay, usually associated with advertisements, not intended to be serious, not intended to be legally binding. Okay, and we'll go, puffery, exactly. Hey, who would have thought that was a word that would be a technical term of art? So that's the issues that Lindley goes through. And then we go through exactly what Bowen thought. So again, he goes through the same kinds of issues. So even if you're not really familiar with the intricacies of each of these legal principles, you can kind of pick up that there was a bit of a headline there, if you will. Okay, so Bowen just goes through the same kinds of headlines. The best bread in Melbourne, yes, exactly, best bread in Melbourne, mere puff. That's exactly the kind of thing that you're normally not going to be liable for. And mostly it will be fairly obvious. Where it's more line ball is something like this, and the thing that pushed it over from being just mere puff and a bit of embellishment to being an indication that there was actual intention to create legal relations and the intention to utter a legally enforceable promise was what? In Carlisle. What did they?
The money in the bank.
Yes.
£1,000.
Yes, exactly. The money in the bank. So they put their money where their mouth is. I mean, that's a fairly serious indication. I mean, £1,000 in the 1890s is a lot of money. Okay. So it's like Lachlan's saying it's like a statement that's fictitious and salesy. Yes, like Red Bull gives you wings. Exactly. Yes. No one's going to sue Red Bull because they haven't grown a pair of wings. Yeah, that's exactly it, Lachlan. So then Smith, I think poor old Smith was having a bit of a lazy day there, and he only discusses some of the issues that the other two go through. He basically says, I agree. He says on a lot of the points, I agree, and I agree. So then it's just up to you in terms of working out what the ratio is for the case. And when you come and sit down to do it, you realise very rapidly how subjective an exercise this is. And for a ratio, what you want to be doing is trying to work out, as I said, not only the consensus that the judges came to, but hopefully something, oh no, Lauren, did they sue Red Bull? Oh, that's hilarious. It's like the people that sue McDonald's for, selling them hot coffee. So what I did was I went through and I looked at the consensus that the judges came to on the various different issues, okay? And then I tried to formulate what I considered to be the most general abstraction that you could take away from that case, okay? So there was a ratio on intention. Yes, it was intended to create legal relations. Why? In this particular case, there was a deposit, showed the sincerity. There was a ratio on acceptance, that there was no need to notify acceptance where an offer is made to all of the world. And I just went through for each one, and then I distilled it down into something a little like this. Where there's sufficient indication of intention to create legal relations, an offer may be made to all the world. If the offer contains clear terms and a promisee accepts and performs the conditions stipulated, this will constitute acceptance. Notification of acceptance to the promisor is not required. So long as some consideration has flowed to the promisor, a contract will have been formed and the promisee may claim the promised entitlement. Okay? So that was my take on Carlile. Now, homogenous is a little bit different. We don't have, luckily enough, all judges providing separate judgments here. The only judge that is in dissent is Kirby, and all of the other justices wrote a joint judgment. So there's one task that's kind of, relieved from you for this particular week, because you know that when you have a majority like that and there's just one judgment, whatever general principles that they come up with from that case will form the ratio of that case. Okay? So then I went through the facts of homogenous, and it seems to me like I didn't think Kirby was never not in dissent. Yes, dear Justice Kirby, bless. And usually they are, often you're tempted to just never read the dissent, but you just know that when Kirby is in dissent, you just want to read it, just for his cheekiness and his sense of justice and his eloquence. He's quite amazing with the way he writes, and he does remind me a little of Lord Denning, who you'll come across in Contract B quite a bit. What is dissent? Can anybody answer, Lachlan? What's dissent? Just answer on your mic if you can unmute.
disagreeing with the general consensus of the other judges.
Yes. Damien, he agreed with the order of the other judgment. Surely that means he wasn't in dissent. Let's have a look here. What did I put? He actually said he's not really in dissent. He comes down with very different views. He's certainly in dissent on the particular issue of whether there was anything worth sending back down to the South Australian Supreme Court, the full court of the South Australian Supreme Court. The majority make it very clear that they really don't think that the matter should be litigated any further. There was almost, you know, the quantum of payout was almost nothing. It was about $30,000 odd, wasn't it? And it was quite amazing. In fact, the majority say this. Yes, they had to do that, Damien. They did have to send it back down, but what they did was they sent it back down with a waggly finger. And normally the Supreme Court will follow the High Court's waggly finger. So they basically say that given that the very basis that the full court overturned the industrial magistrate was erroneous, then really the first instance judgment should stand. Okay. And so that, yeah, he did. But Kirby thought that there was more of a battle that could go on in the South Australian Supreme Court than the rest of them did. So anyone got a good website? Oh, your terminology? There is a free online legal dictionary in the CQU library. If you go onto Lexis Advanced Pacific, you will find it right in there. Everyone, I'm assuming, can I just have a brief poll? Does everyone know how to get onto Lexis Advanced Pacific while we're doing a little bit of skill stuff? Can I have a 1 for yes, 2 for no? Yes, okay. So you seem to, Lachlan, not yet. Okay, well, you just get onto the CQU library website and it's got a whole stack of big buttons. And yeah, you just click on the databases button and then obviously it's got an alphabetical list. You click on L, Lexis Advanced Pacific, and it's right in there for you. So now, this is why I got you to read the case book, the homogenous case is why I got you to read the case book first and then to read the case in full. Now, can I have another poll, please? Who did it that way and who just jumped straight into homogenous? Can I have 1 for read the case book first and 2 for jump straight into homogenous? Okay. So quite a few people. Okay. I would strongly recommend reading the case book first because you can't find the, Jackson, I'm still fighting with the library on that one, the electronic copy of the case book. But basically to answer anyone's burning query, if you don't have the case book, the only paragraphs, yeah, I know, Jackson, I keep telling them and I'm escalating the matter up to the highest library gods. So send me e-power because I have to do battle with the library gods on that one. Email the dean. Yeah. You will make it a sacrifice, not a human sacrifice. Not a first year human sacrifice. Oh, you bought it. I think that that's a really good idea. And here's why. For those people that haven't been to a homogenous yet, what I'm going to do is homogenous. I'm going to take you to the case because here we are. Okay. I prefer, now this will again come back to you guys. in terms of your own personal preferences. I just like Austlii because it's very clean and easy to read. A lot of people like Barnett Jade. I also like Barnett Jade, but for big decisions like this where there's a lot of text, for some reason I just like the layout of Austlii. But the only paragraphs that were extracted in the casebook were, I'll highlight them for you. These ones. Ta-da! That's it. So that's why I wanted you to read the casebook first, so that you kind of knew what you were looking for when you come to the actual full decision, and you know, okay, well, what I have to actually crucially take away from this week's reading is flagged right here in 25, 26, paragraphs 25, 26 and 27. So anything else I read in this case is purely just for me to pick up or try to pick up on the extras that were going on, the things that they didn't describe to me in the casebook. What I'm trying to get you to do is get a little bit of confidence to read selectively, okay? So, for example, when I went through it, obviously because this is the joint and majority decision, that's where I start. I go through the facts, okay? The legislative framework. Now, for all you lovelies that are doing statutory interpretation, I'm sure that you had a little look at all of that with great interest. Personally, because I know what I'm hunting for, I just skim straight over that kind of stuff, okay? Again, the contentions, I skimmed, but at this point I'm kind of trying to get to paragraphs 25, 26, 27 fairly expeditiously. So again, I just read the facts found in the IR court in a kind of a skim way, not really labouring, because quite often they will be explained in more detail in the actual meat of the part that you want to get hold of, okay? Headings. Now, in the olden days, judges never used to use headings. So, man, it really made everyone's life much easier when they started to use headings fairly regularly. Headings are your saviour, because otherwise we would all end up with spectacles like Coke bottles by the end of our law degree. So, you know, you can kind of pick up what the facts were, and then you go to your discussion here and you know, okay, this is what, if I was looking at this case fresh, this is the bit that I'd really need to know about. How would I get there quickly? I would use myself the heading that I'm looking for. So facts, yes, useful to skim through, but if you really need to get to something quickly, don't be afraid to use the guidance of headings. Often, if they start to get too far into the principle underneath the heading that you were looking for, and it all gets a bit too confusing, that's usually a signal that you haven't read the facts quite closely enough. Okay, so it's a bit of an iterative process, but, and I know that others do it differently. You can, if you would like to do so, you can feel free to do it this other alternative way, which is one of my colleagues does it this way. She skim reads the entire thing from top to bottom. And then she goes back and she focuses just on the parts that she wants to take away. Damien's saying something here. Am I right in saying that doing the case note by reading that way, we're not really right writing a full case note, it's more like an intention to create legal relations case note. Yes, yeah, absolutely, because that's the bit that we're interested in this particular scenario. And can I also say that the intention to create legal relations was the main point of this whole case. So by writing an intention to create legal relations case note, you're essentially writing a case note on the whole of the homogenous, because that is the bit that has stuck as the generally accepted ratio. Okay. And then, you know, there was some interesting bits and pieces. Again, you can normally look here. The beginnings and endings of paragraphs are useful to just quickly skim over when you're trying to get to something quickly. Or if you're skimming, you can get an idea of what's going on in that paragraph. And you can see here from 30 onwards, they're starting to discuss and distinguish all of the case law that goes, well, that one's not, but this one is. This one is all of the case law on the presumption that deals with intention to create legal relations in a spiritual setting. Okay, and then you can get down to your next. So then, against this background of the examination of some of the cases relied on, we can go back to the facts. Okay, and then they look at the facts in more detail and they come to their conclusion. Okay, so in my case note here, what I've principally done here is looked at the majority's view of the facts and then looked at their opinion on intention to create legal relations, looked at what they said on presumptions, looked at some of the comments that they made about presumptions, and then looked at how they distinguished the case law that was argued. And then they go and they discuss the errors of the SA Supreme Court. Okay. Now, as for Kirby, he basically says this. He does agree, and you're right, I guess it's not a classic dissent in all terms. He does agree with the majority about the ultimate result. But because he gets there by a slightly different manner, you know, you can't really say that it was, you know, a concurring judgment. So Kirby goes on. I've just made a few notes about what he has said, and I've come up with these two ratio. Okay, the ratios. The Supreme Court was wrong to decide the magistrate failed to conclude intention to create legal relations. And these are what I drew away. So this is a slightly more specific one. There's no general presumption that there will be no intention to create legal relations regarding arrangements between bodies and ministers of religion. All 5 judges held that. But on a more broad basis, you could say something like this. Presumptions are not useful in ascertaining intention to create legal relations and only direct attention as to who has the onus of proof. Okay? And that was just in the majority. And then these are the things that are useful to look at in terms of assessing intention to create legal relations. Okay? So that gives you an idea, doesn't it, about how porous the law is, doesn't it, really? Because it really is down to each person's interpretation. And one thing I want to draw your attention to is how this has been viewed subsequently, and how cases, you know, just how subjective this stuff is. You know, when we were looking at the critical legal studies, you know, those theorists bang on about, you know, law is so subjective, and it's all about power relations and personal perspectives and personal viewpoints, personal agendas. And all of this gets swept under the rug of seeming impartiality and objectivity, when in actual fact, I hope you're getting the feel for this. It's not really, a lot of it is filtered with interpretation and, consideration by each judge. A few weeks ago, I was thinking of all the laws, contract would be the most black and white. No. Yeah. Contract is great because there is no definitive answer, usually. I'm surprised to see the textbook sides. I know contract law is good for the brain and good for the muscles. The more you're carrying around those textbooks, hey man, no need to go to the gym. Okay, so I'm just looking at the Ashton and Pratt case, which I have to say it's one of my favourites from this particular week. Yeah, who does have the time to go to the gym? And so this is the one about the lovely mistress who was jilted by Richard Pratt. And you will come across, I suspect you will come across the antics of Mr. Richard Pratt, who was one of the directors of Visiboard, who engaged in this outrageously anti-competitive conduct, and you'll more than likely come across him in corporations law. So stay tuned. That's just a little bit of a forward advertisement. So that's Richard Pratt in his naughtiness in a corporate sense. This is Richard Pratt in his naughtiness in a contract sense. So here he is basically promising this lovely lady of the night, whom we call an escort, that she should get out of the escort business, and that he would give her all this stuff if she did so, and just attend to his needs. And so, or in more polite terms, if she would be his mistress alone. I thought it interesting because this does bear on the IRAC. Best contract law case ever. Mattel sued Aqua over the rights to use Barbie Girl. Yes, I did like that song, actually. But here is a nice little part of the case that I just wanted you to pick up on, okay? In Homogeneous, the High Court said this, which we all know what it said. The parties are advised to chill. In Homogeneous, the High Court said whether the parties intended to create legal relations required an objective assessment of the state of affairs between them. In that case, the High Court doubted the validity of the use of a presumption that family arrangements were not intended to give legal rise to legal relations. So you can see how here, because the point of interest is whether or not there's a presumption that applies to family arrangements, what they're doing is couching the ratio of Homogeneous in terms that are more directly relevant to the case in front of them. Okay, so they're kind of moulding the ratio of Homogeneous and saying, how do we apply what they said in that case here? What do they pick out of Homogeneous? The fact that family arrangements were not intended to give rise to legal relations had previously been a presumption, right? Almost borders on a business arrangement. Yes, it does. Okay. So then they say, there is this other little case, quite recent, 2013. In contract law terms, that is recent. 5 years ago is recent. I mean, in Twitter terms, yesterday is ages ago. In contract law moves at glacial pace, people, and anything that's within about a tolerance of 50 years is still considered recent case law. We'll be coming across cases from the 1600s in Contract A. So, Scion is quite recent in our neck of the woods. But then they say, okay, there's this inconvenient case. Look at this. Scion, they said, and this is 2013, so after Homogeneous, with Emmett said, with whom Baston and Barrett agreed, that as a matter of known experience, when family members make a promise to each other, it's unlikely they intend it to be legally binding, and the vaguer the language of the arrangement and the greater its informality, the more difficult it will be to rebut the presumption. So they've just said the High Court's told us that there are no presumptions. And then they've said, oh, hang on, this case is in our jurisdiction, but it seems to go directly against what the High Court said. What are we going to do with that? They sidestep it. Notwithstanding what was said in this court, in my opinion, the effect of the decision of the High Court was that in considering the issue, recourse should not be had to presumptions. Okay? So they are directly saying they're confronting the issue. There is this precedent there, but in our opinion, we've got to follow the High Court. Of those two precedents, which is the weightier? We're going with the High Court. Okay? So I want you to be picking up on the different ways that judges and you will be distinguishing cases as you go along in Contract A and Contract B. Because someone said to me, you know, when I posed the question for your skills component, how do you distinguish something? And the response was, well, you say that the facts in this case are quite different to the facts in the precedent case, and that's how you get around it. That's one way how you get around it. There are quite a number of ways, and this is another. Okay, we're faced with two. Which is the weightier? The High Court. Which do we think is obviously the more correct? Got to be High Court. How are we going? High Court. Yes? So just start gathering all of these little bits and pieces as you go on. It's amazing how the brain filters all these stuff through and makes sense of it all, isn't it? So that is just my little comment about homogeneous. The old way of looking at things was obviously rebuttable presumptions. What are they? Let's go. What are rebuttable presumptions? Oh, sorry, Damien. Somewhere in the textbook it says something along the lines of you can only truly determine the true ratio by analysis of how it has been used in other cases. Yes, and that's generally speaking how it will filter through. You will get a ratio that one judge proposes, another judge, you might find a ratio that's proposed of a case in scholarly articles. And then later judges might pick up on those scholarly articles and refer to them in their decisions and say, we think that this is how this case should be interpreted. And that's exactly what we're finding with homogeneous as we go through. When my colleague first started this particular unit, it was in 2014, I think. And so homogeneous was still kind of in its infancy. So there was still quite a lot of the presumptions being applied because no one was really sure, as I said to you in the videos. There is that little crack of uncertainty in homogeneous because of the way that that sentence runs on. And so now what's happened is we've filtered through, you're getting more and more cases like the Ashton and Pratt case where they're saying, hang on a minute, this is what we think that homogeneous says. And then it gradually ossifies into a generally accepted ratio from that case. So if someone can prove the presumption wrong, is a rebuttable presumption? Yes, it is. Absolutely. So they are rebuttable, are a Yep. In civil, the standard is always balance of probabilities. In criminal, it'll be something else. Does anyone know? Beyond reasonable doubt. Okay? Much tougher. So we're just saying, is it 51%? Okay, that's all good. So, in terms of rebuttable presumptions, I've got here, I'll just copy this in here. In Merit and Merit, for example, that was a case between husband and wife. the presumption ran like this. If husband and wife are living together in amity, in friendship, love, natural affection, it's natural to presume that their discussions about money matters are not intended to create legally binding contracts. So the kinds of factual circumstances surrounding the recognised relationships aren't normally of a nature to give rise to an intent to create legal relations. What are the various categories that used to apply? Can you remember? What's the first one? Well, we know the first one. Husband and wife. Family, yep. Commercial, yep. Social relationships, yep. Commercial relationships, that's right. So with the husband and wife, is it presumed to, is there the intent presumed, or is normally there a lack of intent? That's right. Emily?
Can I ask a question on that?
Yeah.
So wouldn't that be complicated based on things like, you know how in Australia, if you've been with a partner for 6 months or something, she's entitled to take you for half of your stuff, or whatever the de facto relationship laws. Wouldn't that complicate this matter?
No, because de factos are considered to be in the same category as husband and wife.
Yeah, but that's what I mean is like it's not a legally binding contract, so to speak, but wouldn't there be some weight to it based on their relationship?
The nature of a relationship of husband and wife is considered to be the same as the relationship between de factos.
Yeah, that's what I mean is well, what it's saying is
they're saying that they're living in a situation of natural love and affection is the normal term used.
Yeah.
Whether that's
what I mean is the discussions about money matters are not intended to create legally binding contracts, but wouldn't they to some extent be contracts between each other?
Between the husband and wife?
Yeah, as partners.
That's normally how the disputes arise. Yes.
Yeah. In terms of settling them, though, wouldn't that be how they would be settled as well?
Well, the question that is usually asked is that one party's promised to give something to the other party, and the other party is trying to enforce the agreement. And in order to avoid the agreement, one of the parties is saying, hang on a minute, there's no valid and legally enforceable contract. Why is that? Because we never intended there to be a contract here in the first place. This was just an arrangement between husband and wife. This was never intended to come before the courts.
Okay, fair enough. It's still confusing to me, but I'm sure it'll make sense eventually.
Yeah. One of the precursors to actually forming a valid contract is a requirement on the part of both parties that the thing they are about to agree on will be the kind of agreement that is intended to be enforceable by a court.
Oh, okay, yeah, that makes more sense. Cool. Thanks for that.
Yeah. So normally between a husband and wife, you would say, if you're going to do the dishes, I'll do the laundry. You don't intend that that's ever going to, if one party doesn't do their chore, you're not going to end up in court. Yeah? Because there's no intention to create a legally binding contract.
I'm hoping you haven't been through divorce. I have.
Yeah, twice, man.
Oh, really? Yeah, it's fun, isn't it?
Oh,
no.
Sorry
Thanks for that.
Sorry to butt in, AJ. Isn't there a case? I can't remember how old it was. Where some old bloke he went to India, and was agreed to pay his wife that he'd fallen out of love with. And when he couldn't do it, or he forgot to pay for 2 months, she tried to sue him. And that's where the court said, well, hey, actually, no, we're not going to get involved in all the bickering between every husband and wife from here on forward.
Yeah, that was Balfour and Balfour.
That's right, yeah.
Yeah, and it was held that there was to be no intention to create legal relations there. Although it was my understanding that they hadn't separated at the time of the agreement. Normally, once there is a separation, or if there is an agreement made in anticipation of separation, normally there will be an intention to create legal relations. Yes? Family is another one of those, no, not normally presumed. What's the deal with commercial? Is there a presumption or no presumption of intent?
There is a presumption that if it's done in business, the intent to create was there, but there is some little minor thing or something that you can prove that it wasn't there.
Yes, exactly. So in most of these scenarios, there'll be presumed to be no intent to create legal relations. Now, let me just explain to you a little bit about what Imogenes was saying. What they're saying is, in this day and age, there are so many different kinds of relationships, and so the possibility of having different factual scenarios come before a court are immense. It's limitless. So can we really categorise into little pigeonholes and tie them up with a neat little ribbon to say that all husbands and wives won't intend to create legal relations? Probably not. Okay, so what does a presumption get us in most of those circumstances? A presumption will be to the fact that no, there's probably not going to be intention to create legal relations. So then who has to prove that there is an intent to create legal relations? What will they want to be doing? If they want to show that there was an intent to create legal relations, what are they going to be trying to rely on? They're going to try and rely on the contract, aren't they? So it's the party that wants to have the contract recognised as justiciable by the court that's going to have to rebut the presumption. Yes? And what the High Court's saying is the onus of proof, is usually on the plaintiff, the one that's trying to rely on the contract. And the High Court's saying in most of these presumption scenarios anyway, it's going to just simply tell you where the onus of proof is. And usually the onus of proof will be on the party that's trying to prove the contract, that wants to rely on the contract. So why don't we just say the onus is on the party that wants to rely on the contract, wants to prove the contract, and take away all of this needless step of having presumptions. Doesn't get us anywhere. Generally speaking, the only real difference will be in commercial scenarios because the presumption went the other way. So the person that had to do the proving was the person that wanted to knock down the contract and not rely on the contract. Okay, get out of the contract, for example. But you know what? If you are the party that is seeking to rely on a commercial, a contract that was made in a commercial circumstance, it's not going to be hard to show that there was an intention to create legal relations, is it? The burden, the additional burden that's placed on a plaintiff here, would the presumption be implied by a lawyer-drawn contract? If in commercial or business? Yes, Lachlan, yes. Particularly where there are legally drafted documents, you need to say, well, the parties have turned their mind to the fact that this might end up before a judge. Imogenes wasn't clear on removing presumptions from commercial cases. Steph, they said presumptions are pretty useless generally. They said, even if you ring up Jim's Mine and say, come my yard, that phone call counts as a contract once a booking is placed. Yes, not sure what your question was. Once the money is handed over. well, that's an offer that was accepted. The terms are agreed. The consideration is agreed. So once the acceptance is communicated, then you're going to have a contract. And I'll leave that just as a bookend maybe for the last little bit here. But what I want to go through is very briefly, the IRAC that you're meant to be doing this week. And we have a couple of extra minutes because my Contract B class is not starting till 7:15 nowadays. So we have Katrina and Richard. Has everyone read through this? Can I have a 1 if you've read through this? And a 2 if not? Okay. All right. Lachlan. You know what? Is it on the noodle? Yeah, it's on the noodle. That's going to be my go-to word now. It's on noodle. So we just have this little scenario. Katrina and Richard were both big fans of 1950s retro styling. Katrina owned a dress shop, specialised in rock and roll style dresses. Most of these she designed and manufactured herself. She was always looking out for old magazines or other sources of inspiration. Richard, on the other hand, ran a record store selling old-fashioned vinyl records. He had a silent business, authentically repairing jukeboxes. One day she comes in. They become friends. They stayed in touch for about a year. They are both in business already. Obviously, he repairs and does all this vinyl records and repairs jukeboxes. She does owns a dress shop. They stayed in touch for a year, and then she suggests they should combine their efforts to start running a business. He agrees enthusiastically. Both experienced, both understood the need to have their paperwork in order. They recognised that running a partnership would be very different from each of them running their own business. Okay, partnership here. Partnership agreement is what they're looking at. They brought in a third partner who had previously run a cafe. They opened this business as a partnership. Obviously, they've entered into a formal partnership agreement. For a while it did well, and then Richard and Katrina end up together as a couple. By the second anniversary, everything's going Katrina's way. She's getting a lot of personal business rather than the joint business. And Richard and Emma are starting to get a bit ticked off. The dissatisfaction was putting pressure on the relationship. They hung in there for a while, but then Richard and Emma come to see us for advice about whether they can avoid the contract they all signed when the diner was first opened. Issue, obviously, for us, whether they can successfully argue the contract was never validly formed because there was no intention to create legal relations. In the rules section, you're going to be talking about homogeneous, and you're going to be trying to formulate a nice little concise ratio there, okay? Presumptions are not useful. Instead, the inquiry may take into account all of this. The onus is on the party relying on the contract, okay? Tell me then, how would you go about answering this? I've started here for us. Katrina will be likely trying to rely on the contractual relationship to prevent Richard and Emma leaving in an unplanned manner. So the onus is going to be on her to show that there is a validly, legally enforceable or justiciable contract. Okay? So the hard work really is not on our guys' behalf. The hard work is on Katrina's side of the fence. However, before you can really advise Richard and Emma what to do, they're going to need to know what any outcome would be. So you need to go through and see whether or not Katrina would be successful in proving a validly formed contract. And that will include an intention to create legal relations. Now, here, if you look at the facts, we do have a friendship between Richard and Katrina. So in the old presumption terms, what would be happening? How would the presumption work? Would Richard and Katrina have to do the hard work if a presumption was applied because of their social relations? Or who would need to prove? So we've got, Richard and Emma against Katrina. So assuming that there was this friendship between Katrina and Richard, now Richard's trying to say that there was no contract. What's the presumption if there was a social relation? Presumption of intent or not? Richard and Emma would have to prove no contract. Actually, Steph, if there was a presumption applied in areas of social relations, generally speaking, they will assume no. But there have been a number of different cases which have held that arrangements between friends have been intended to create legal relations. So,
AJ, can I ask a question? Because when I read this, the part where it says the parties had to negotiate and agree on business settings, and they brought in a third person. So what's her name wasn't even friends to begin with. Does that not make it seem more like it was business? Like it's not just two friends, they've thought about it, they've negotiated, and they've brought in a third party. Yes. And then they've fallen into a romantic relationship, and then sounds like he's got jealous and now they want to dissolve it. Yeah. Like, I don't know, it just seems like it is a contract.
The only thing I was trying to flag for your attention was that we have no real difference in the way things would run now under homogenous than we would if we were just looking at the issue of social relations, because the presumption in social relations would be there's no intent to create legal relations. So the hard work would be on Katrina under the old way of doing things. Under this way, you're absolutely right. Under homogenous, we have to look at the whole relationship theory. We have to look at the whole context. And here we have a social relationship, but they'd known each other for approximately 12 months, but they brought in Emma, and she was not friend of either in a close social sense. Yeah. So I think that's definitely one factor that counts towards it being commercial. What's something else? I'll flip up to the facts again. Experienced business operators. Both understood the need to have paperwork in order. So what does that suggest to you?
They need answers for each other if they really want to.
Sorry, you phased out there.
Because they were experienced business owners, wouldn't that mean that they had the intention and they also considered the options? So, yeah, the intention is plainly there because they've done it all before separately, and then they chose to join up and create a new business.
Exactly. And I don't think you could say in that circumstance that it had much of the hallmark of an informal, friendly deal. If they've gone to the trouble to have a formal partnership agreement drawn up, it's a commercial agreement because there was economic entitlements for all parties. No, Nancy, you can't say that if there was some kind of financial reward or entitlement at stake that it's necessarily going to kick over an intention to create legal relations, because most cases here will involve a fight over some kind of economic entitlement. So you can't go from one end to the other and try and generalize here. Okay. Anything else that we can dig up that we think might show that there was intention to create legal relations?
I thought the fact that Richard wasn't complaining when he was getting business as well, when they were both getting flow on business, everything was fine. But now that Katrina is continuing to get flow on business in the second year and he isn't, this is where the problem is. So I wonder if he was still getting the same business in his shop, if that would have changed the outcome.
Well, he probably wouldn't have agitated against it. No, that's true. People only complain when they see dollars going the wrong way. Yes, and that's how we make a living. Okay, so it certainly seems to me the subject matter of the agreement, that to me is another flag here. And the fact is that it was a partnership agreement. Where is this? Running a partnership, and that's a very serious relationship. A partnership in formal legal terms is a very solemn relationship, and it's a business relationship. So, bye, Jessica. So that I thought could also be one thing that might flag for us that there's an intention to create legal relations. So all in all, I think our advice to Emma and Richard would be that if the court considered the subject matter of the agreement, the status of the parties, well, here it's within a commercial context, and that whole issue of Richard and Katrina getting a personal relationship on, I think that's just a bit of a furphy. And other surrounding circumstances, language, conduct. We haven't seen the terms of the agreement, but I think there is sufficient for us to say here to Richard and Emma that a court would likely conclude that there would have been intention to create legal relations. Yes? Yay! I'll finish writing up that IRAC. I'll put it up at the end of the week. And if you want to send me in your IRACs, please start. This is just stuff that I've bashed out while we're talking, but write up a nice, beautiful IRAC for me and send it in for feedback. Yay! Any queries? Bye, guys. Have a good week. Bye. Bye.